Did you know that India's parliament, the very heart of our democracy, is actually, uh, unlike its British counterpart, not supreme?
And that the way we remove a vice president is fundamentally different from how we remove a president. The process doesn't even start in the same way.
Exactly. It's a fascinating asymmetry of power, and it's all by design, meant to build a federal check right into the union's core.
We're diving deep into that engine room of Indian democracy today. We're going to explore exactly these constitutional constraints.
We'll be breaking down how the Indian system, maintains its unique blend of collective responsibility and at the same time, limited power.
And we'll be looking at the specific surgical tools from something like a censure motion all the way to the special federal checks given to the Rajya Sabha that keep the executive accountable and the whole constitutional structure stable.
Welcome back to the Deep Dive, the place where we streamline complex source material into actionable knowledge, perfectly tailored for high-stakes preparation, like the UPSC examination.
Our mission is to really cut through the noise and deliver that precision insight, the kind that moves you from just knowing the facts to actually understanding the constitutional intent behind them.
Before we jump into the deep end, we want to give a massive shout-out and a huge thank you to all our existing paid members.
Yes, absolutely. Your support is invaluable. It helps us dedicate the time and, frankly, the resources needed to bring you this highly detailed, super useful content, linking these constitutional concepts directly to exam patterns.
Your commitment truly makes this level of rigor possible. It really does.
So if you find this content valuable, and trust us, today's deep dive is dense with those critical distinctions you need for high-level analysis, please take a moment right now.
Subscribe to the channel and hit that notification bell. And we're humbly requesting those who are capable to join our paid membership on YouTube. It really helps support our mission.
And don't forget to like this deep dive and share your valuable comments below. It genuinely helps the content reach more learners like you.
Okay, let's unpack this. Our mission today is a comprehensive deep dive into the legislative core of the Union Parliament.
We're primarily basing this on the foundational concepts from M. Laxmikanth's 8th edition, focusing specifically on Chapter 23.
We're looking at the structure, the functioning, that sophisticated machinery of accountability, and of course the crucial relationship between the legislature and the executive. We are going way beyond just the basic functions.
And critically, we'll directly connect these concepts to the kind of analysis required in the UPSC mains exam. We'll be tying together these abstract legal structures with real-world policy outcomes.
Looking at previous year questions PYQs that demand an understanding of how parliamentary scrutiny affects implementation in fields like, say, land reforms or food security.
This isn't just theory. This is the mechanism of governance in action.
Let's start at the very bedrock then, the principle of parliamentary government itself. It's a system India largely inherited from Britain, but we modified it significantly to fit our unique federal needs.
Yeah.
When we talk about the fundamental characteristic that defines the Indian parliamentary system, we have to start with the nature of its leadership, right?
That's the one. The defining characteristic is the dual executive. We established a system with two heads, which, often confuses people new to the Constitution.
Right.
You have the president, who is the nominal executive. You'll see terms like de jure or titular head of state. They are the symbolic embodiment of the nation, the constitutional figurehead.
And then you have the prime minister.
And then you have the prime minister, who is the real executive, the de facto head of government. The PM, leading the Council of Ministers, holds the actual, tangible reins of political power.
This whole dualism thing is not just a convention, is it? It's written right into the Constitution.
Yeah.
There's a specific article that dictates how power flows.
That's Article 74. It mandates the existence of a Council of Ministers, led by the Prime Minister, and their sole job in this context is to aid and advise the President in the exercise of their functions.
Okay, aid and advise. That sounds a bit soft.
Well, it used to be. But crucially, as amended over time, the advice tendered by this council is now binding on the president. The 42nd and 44th constitutional amendments really cemented this relationship.
So the president can't just veto the will of the elected government.
Not really. They can perhaps ask for a reconsideration once, but ultimately they are bound by that advice.
But if Article 74 makes the advice functionally binding, isn't the nominal role of the president almost entirely symbolic? Can we really call it a dual executive if one part is constitutionally required to act on the instruction of the other?
That's a great question, and it really speaks to the wisdom of the framers. While the president is bound to act on advice, they are far from redundant. Their role is absolutely pivotal in times of political crisis.
For instance.
For instance, in determining who can form a stable government after an election, or when a government loses confidence in the House. The president acts as a constitutional guardian, ensuring the political process stays tethered to the Constitution.
So they're the moral authority, the continuity of the state, kind of above the day-to-day political fray.
Exactly. So yes, it is dual, but it's weighted very heavily toward the prime minister and the council of ministers.
Okay, understanding that structure, let's go back to that foundational question.
Right.
Why did the Constituent Assembly choose this? Well, this complicated system. Why not the U.S.-style presidential model with its clear, separated powers?
The historical context here is absolutely crucial. The founders were concerned primarily with political stability and, even more importantly, with executive responsibility to the legislature.
Responsibility being the key word.
The key word. The greatest advantage of the parliamentary system is the built-in harmony and cooperation between the legislative and executive organs.
Because the executive is drawn from the legislature.
Precisely. Since the ministers are drawn from and remain part of the legislature, there's inherently less scope for disputes and conflicts compared to the strict separation you see in the U.S. model, where a divided Congress and presidency can lead to, total governmental gridlock.
So stability is achieved because the executive's very existence is tied to the legislature's continued confidence in it.
Exactly. And that necessary dependence leads directly to the second and perhaps most vital merit. It establishes a responsible government.
Okay.
Ministers are collectively accountable to Parliament for all their actions or even their omissions, and Parliament is equipped with the tools to demand that accountability.
And this isn't just a once-a-year thing.
Not at all. This control is exercised constantly through the use of the question hour, calling attention motions, adjournment motions, and of course the ultimate test of confidence, the no confidence motion. This constant scrutiny prevents the executive from becoming dictatorial.
And beyond just responsibility, the system is also meant to promote inclusion, right?
Absolutely. A key democratic advantage is wide representation. Since the Council of Ministers draws members from the entire parliament, which in turn reflects the vast diversity of the country, the council often accommodates various regional, communal, and sectional interests.
Which is vital for a country as diverse as India. It ensures decisions reflect a broader national consensus.
It's built into the DNA of the system.
Okay, let's unpack this a bit more, because the Indian model, while inspired by Westminster, is not a simple copy. This is where the critical analysis really begins. The difference between the British model and ours, especially on the concept of sovereignty.
This is a foundational distinction. The British system operates on the doctrine of the sovereignty of Parliament, something often associated with A.V. Dicey. Historically, the British Parliament is considered supreme.
Meaning it can do anything.
It can theoretically legislate on anything, and no court can declare a primary piece of legislation void.
But India's parliament is emphatically not supreme.
Not at all. It's a creature of the Constitution operating under defined limits.
So we have constitutional supremacy.
Correct. India adopted constitutional supremacy, placing the Constitution above all organs of the state, including the legislature. Our parliament enjoys only limited and restricted powers. This crucial limitation stems from four major interlinked factors that were deliberately built into our constitutional scheme.
Let's detail those constraints because they really define our system's uniqueness.
Okay, first, the existence of a written constitution. Unlike the UK's uncodified system, our constitution is a detailed fundamental law. It explicitly demarcates the powers, procedures, and jurisdictions of Parliament. Parliament cannot legislate outside these written boundaries. Simple as that.
Second constraint, the federal system itself.
Precisely.
Yeah.
Federalism divides the legislative domain between the center, with its union list, and the states, with the state list. Parliament cannot usually just encroach upon the state list subjects, so its power stops at the limits of the union list.
Third, and this is a big one, the fundamental rights.
A huge one. The fundamental rights in Part 3 act as constitutional restrictions on legislative power. They limit the state's ability to encroach on individual liberties. Any law that violates a person's fundamental right can be challenged.
And the fourth, which is the institutional mechanism that enforces the other three, is judicial review.
Absolutely. The power of the Supreme Court and the High Courts to scrutinize parliamentary laws and declare them void or ultra vires, beyond their legal power if they contravene the Constitution, is the ultimate constraint.
So unlike in Britain, our judiciary stands as a sentinel on the qui-vive.
Ever vigilant, especially over fundamental rights, ensuring that Parliament acts within its constitutional boundaries.
So the Indian Parliament is constrained by both the text of the Constitution and the authority of the judiciary. That is a massive conceptual difference from the mother of parliaments in the UK.
It is, and this design reflects the founders' priority. They preferred a system that was accountable and balanced over one that was efficient and, well, supreme.
That brings us perfectly to the practical application of this system, tying it directly to exam-relevant material. We see UPSC mains questions that ask us to critically discuss the implementation of major initiatives, like the Food Security Act, or the link between constitutional ideals like the DPSPs and real-world outcomes, like land reforms.
This is where understanding Parliament's accountability function becomes so vital. Parliament passes these monumental laws based on grand ideals, like the commitment to socioeconomic justice in the DPSPs, which inspired land reforms.
But passing a law is just the first step.
Exactly. The executive has to actually execute it. And often, implementation is where the system breaks down.
Right.
When implementation is poor, maybe land records aren't digitized or tenancy reforms aren't properly enforced, that gap between the legislative intent and the executive delivery has to be measured and corrected.
And that's Parliament's job.
That is Parliament's job. This is done via parliamentary scrutiny. If land reforms fail, it directly impacts agricultural productivity, which is a clear UPSC mains topic. If the executive fails to implement provisions for tribal areas, it can lead to social unrest and internal security challenges.
So parliamentary scrutiny, through questions, discussions, and those specialized committees like the Departmental Standing Committees or the Public Accounts Committee, is the primary tool to measure that gap.
The gap between the grand legislative intent, the constitutional ideal, and the messy, sometimes failing executive delivery on the ground.
It forces the executive to account for policy failure, demanding utilization certificates, explaining budget shortfalls.
It transforms the abstract concept of responsible government into a concrete, measurable process of checks and balances.
All right, let's move inside the Parliament building itself and look at the structure and tenure of the two houses. Let's start with the Rajya Sabha, the Council of States. This house is meant to embody the federal character of the Union.
The Rajya Sabha is fundamentally designed for continuity. That's why it's known as the continuing chamber or the permanent body. It is never subject to dissolution.
And what's its maximum strength?
The maximum strength is fixed at 250 members. Of these, 238 are to be the representatives of the states and union territories, indirectly elected based on population.
And the other 12? The nominated members have a very specific constitutional function, don't they?
They do. The remaining 12 members are nominated by the president. This nomination is based on their special knowledge or practical experience in 4 distinct fields: literature, science, art, or social service.
It's a way to get experts into the legislative process without them having to run for election?
Exactly. It ensures eminent non-political professionals can contribute.
What about its current strength?
Currently, the strength is 245 members, 225 from states, 8 from union territories, and those 12 nominated members.
And if you need to know the specific allocation of seats for each state?
Then you go to the 4th schedule of the Constitution. That's where it's all detailed. If you want to know how many seats Uttar Pradesh has, you check the 4th schedule.
Now, since it's a continuing chamber, how does its tenure work? How do you ensure continuity but also have democratic turnover?
Its members have a fixed 6-year term. But crucially, approximately 1/3 of its members retire every 2nd year. This staggered retirement process ensures that there's always a 2/3 majority of the House that possesses institutional memory and experience.
So it maintains its continuous nature even as members change.
That's the idea.
Okay, now let's contrast that with the Lok Sabha, the House of the People, the non-continuing chamber, which represents the direct democratic will of the nation.
The Lok Sabha is the directly elected House, and its normal term is 5 years, calculated from the date of its first meeting after the general elections.
And after 5 years, it just dissolves automatically?
It does, but the constitutional power of dissolution rests solely with the president. The president is explicitly authorized to dissolve the Lok Sabha at any time, even before 5 years are up, if advised by the Council of Ministers.
And that can't be challenged in court?
Not usually, no. It's considered a political question.
What happens in a crisis? Let's say a national emergency. Can the government just extend its own life and postpone elections?
Yes, and this is a vital provision to study for the exam. Under a national emergency proclamation under Article 352, the term of the Lok Sabha can indeed be extended by a law of Parliament.
For how long?
It's granted 1 year at a time for any length of time, as long as the emergency continues.
But there must be a limit.
There is. The Constitution imposes a hard limit, a necessary safeguard. This extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. This strict limit is designed to ensure that democratic governance is restored promptly.
Right, so the executive can't use a crisis to perpetuate its term indefinitely.
Exactly.
Speaking of tenure, members can also be removed midterm, particularly under the infamous Anti-Defection Law, which is in the 10th schedule. This is constantly in the news, so laying out the precise grounds for disqualification is essential.
The 10th schedule was introduced to address the evil of political defections, which, plagued early Indian politics. A member can be disqualified under 4 explicit scenarios, and we should detail them carefully.
Okay, what's the first one?
First, if they voluntarily give up membership of the political party they were elected on. This is usually determined by their actions, not just a formal resignation letter.
And the second. This is the one we hear about most.
It is. The second ground is if they vote or abstain from voting in the House, contrary to any direction given by their political party, that direction being the famous whip. If you defy the whip on a key vote, you can face defection proceedings.
What about independent candidates?
That's the third ground. If an independently elected member joins any political party after the election, they're out. They have to remain independent.
And nominated members?
The fourth applies to them. If a nominated member joins a political party after 6 months from the date they took their seat, they get a 6-month window to decide. After that, they have to stay unaligned or face disqualification.
Now, who's the ultimate authority here? Who decides if a member is disqualified for defection?
The question of disqualification under the 10th schedule is decided by the presiding officer, the chairman in the Rajya Sabha, and the speaker in the Lok Sabha.
For a long time, that decision was considered final, right? Immune from court interference.
It was. It was seen as internal parliamentary business. That sounds like a massive concentration of power in one person.
It was, and this is where we have to highlight the landmark legal challenge, the Quijano-Holohan case of 1992. Before this ruling, a paragraph in the 10th schedule essentially barred courts from intervening.
But the Supreme Court stepped in.
It did. In Quijano-Holohan, the Supreme Court struck down that paragraph as unconstitutional, but it upheld the rest of the anti-defection law.
What was the practical outcome of that ruling? What did it mean for judicial oversight?
The Supreme Court ruled definitively that the decision of the chairman or speaker regarding disqualification is subject to judicial review.
A crucial check on the presiding officer's power.
Absolutely. It ensures that even the internal disciplinary mechanisms of Parliament have to adhere to principles of natural justice and constitutional fairness. The courts can now scrutinize decisions for, say, bias or arbitrary action.
Though they can't intervene before the presiding officer has actually made a decision.
Correct. The process has to play out first.
Okay, moving on to the leadership within the houses, let's talk about the key officials. The Speaker and the Deputy Speaker. Their financial arrangements are constitutionally secured to ensure their independence, aren't they?
That's correct. The independence and dignity of these offices, Speaker, Deputy Speaker, Chairman, Deputy Chairman, are secured by their financial provisions. Their salaries and allowances are determined by Parliament. But critically, they are charged on the Consolidated Fund of India, the CFI.
We hear that term charged on the CFI a lot. Can you explain what charged means in practice versus something that's voted upon?
When an expenditure is charged on the CFI, it means it's mandatory expenditure. It does not require the annual vote of Parliament. It's non-votable. This mechanism prevents the executive from using financial leverage like threatening to cut salaries to influence the neutrality of the presiding officers.
It puts their pay above the political fray.
Exactly.
And what about the Deputy Speaker? What's their specific role, especially in extraordinary circumstances?
The Deputy Speaker performs the duties of the Speaker's office when it's vacant or when the Speaker is simply absent from a sitting. When acting as Speaker, they have all the Speaker's powers. But they have one additional, very specific duty.
Which is?
If a situation requires a joint sitting of both houses of Parliament, which we'll detail later, the Deputy Speaker presides over that joint sitting if the Speaker is absent.
Now we get to the core mechanisms Parliament uses to control the executive. The procedural tools or devices that bring the administration under scrutiny and ensure responsibility.
Let's first cover the auxiliary functionaries. We hear about the leader of the House and the leader of the opposition. Are these positions constitutionally mandated, like the Speaker?
This is a crucial nuance for the exam. These positions are not explicitly mentioned in the Constitution. The leader of the House is defined in the rules of the House. It's usually the Prime Minister if they're in the Lok Sabha.
And the leader of the opposition?
That position is recognized by a separate parliamentary statute, not the Constitution. This statute grants them official status, pay, and perks equivalent to a cabinet minister, acknowledging their critical role.
And the whip. The mechanism for party discipline we talked about with defection. Where is that mentioned?
The office of the whip is probably the most powerful convention-based office. It's mentioned nowhere. Not in the Constitution, not in the rules of the House. It is purely based on the conventions of the parliamentary government.
So the power to discipline members for defying the whip comes entirely from party convention, but has huge consequences because of the 10th schedule.
Precisely. A powerful, non-constitutional tool of political control.
And for those important public matters that don't fit into question our other motions.
Those are raised under two equivalent rules. The special mention in the Rajya Sabha and the notice under Rule 377 in the Lok Sabha, they're like procedural escape valves for raising urgent issues.
Okay, now let's raise the temperature. Let's look at the motions designed specifically for executive control, starting with the one that causes the most confusion. Censure motion versus no confidence motion. This is essential knowledge.
It truly is. Both are tools to test the confidence of the House, but they differ fundamentally in their target, their reasoning, and their consequence.
Let's break down the critical differences. First, the need to give reasons.
A censure motion is a surgical strike. It must state the specific reasons for its adoption. It has to cite the precise policies or actions the House wants to condemn or censure.
And a no confidence motion.
That's the nuclear option. It need not state any reasons at all. It simply asserts that the House no longer has faith in the government, period.
And what about the target? Who are they aimed at?
The censure motion is specific. It can be moved against an individual minister, a group of ministers, or the entire council of ministers. It's often tactical to pressure a ministry.
Where's a no confidence motion?
The no confidence motion targets the principle of collective responsibility. It can only be moved against the entire council of ministers collectively.
So a censure motion is like a targeted strike, and no confidence motion brings down the whole government structure.
Perfect analogy. And the consequences follow that logic. If a censure motion passes, the council of ministers does not have to resign, though it's a huge political blow.
But if a no confidence motion passes,
the entire council of ministers must resign. They have lost the confidence of the Lok Sabha, their core democratic mandate.
Okay, moving to financial accountability. Let's discuss the budget process, the primary tool of Parliament's fiscal control.
We have to start with the correct constitutional terminology. Article 112 refers to it as the annual financial statement. The word budget is just the popular name we use.
And there was a big timeline shift recently.
Yes. Since 2017, the presentation was advanced to February 1st. The strategic reason was to get the entire process, including the appropriation bill, passed before the new financial year begins on April 1st.
Can you walk us through the 6 crucial stages of the budget?
Sure. It's a rigorous process. First is the presentation of the budget by the finance minister. Second, a general discussion on broad principles happens in both houses.
Then the detailed work begins.
Exactly. Third is scrutiny by departmental committees. Parliament adjourns for a few weeks, so the 24 standing committees can scrutinize the demands for grants of their respective ministries.
And stage 4.
Voting on demands for grants. This is the most crucial stage for control, but it happens exclusively in the Lok Sabha. This is where members can move cut motions.
Then the 5th and 6th stages are about making it law.
Right. 5th is the passing of the appropriation bill, which authorizes the government to actually withdraw funds from the consolidated fund. And 6th is the passing of the finance bill, which handles all the tax proposals.
Speaking of timing, there's a key problem. The government needs money on April 1st, but the full budget process often drags on. How is that gap funded?
That gap is managed by an essential device called the vote on account. Since the government can't withdraw money until the full Appropriation Act is passed, the Constitution lets the Lok Sabha make a grant in advance, the vote on account.
So it's like a temporary budget.
Essentially, it's typically for 2 months and covers only expenditure, not tax changes, just to keep the government machinery running.
Despite this intricate system, there are significant critiques about how effective Parliament's financial control really is. Why does the power of the purse often seem more theoretical than real?
The reality is that several structural factors undermine Parliament's ability to scrutinize finances effectively. It creates a huge accountability deficit.
That's the first problem.
First, the technical nature of the demands. Most parliamentarians are generalists, not financial experts. It's genuinely difficult for them to understand hundreds of pages of highly technical budgetary details.
It's just complexity overload.
In many ways, yes. Second, there's systemic executive dominance. The executive, the Council of Ministers, formulates the policy and also commands a majority in the Lok Sabha. This inherently weakens financial control. It's hard to criticize a budget your own party is pushing.
And there's a procedural flaw, too, right? The guillotine.
A critical procedural flaw. Parliament often runs out of time to debate every single demand for a grant. So at the end of the voting period, the Speaker applies the guillotine. All remaining demands are just put to a vote simultaneously with zero debate.
Zero debate. That sounds like it defeats the whole purpose.
It dramatically weakens the concept of the power of the purse. Sometimes over half the budget goes completely unscrutinized. Finally, you also have factors like the lack of a strong opposition and a general decline in parliamentary behavior, which contribute to the ineffectiveness of legislative control.
We've established that despite the harmony of the parliamentary system, conflict between the two houses is inevitable. When they deadlock over a bill, the Constitution provides a mechanism for joint resolution, the joint sitting of Parliament.
The provision for a joint sitting is a mechanism built into the Constitution to resolve disagreements on an ordinary bill or a financial bill.
It's crucial to know which bills this does not apply to, as the exclusions say a lot about the power hierarchy.
Right. It explicitly does not apply to two crucial types of bills. First, money bills. The Lok Sabha has overriding powers there, so a joint sitting is pointless.
This decade.
Second, and this is highly significant, it does not apply to constitutional amendment bills. These must be passed separately by each house by a special majority. The framers didn't want fundamental changes to be pushed through by a simple majority in a joint sitting. It requires federal consensus.
So under what conditions can the president actually summon a joint sitting? What counts as a formal deadlock?
There are three conditions. One, if the bill is rejected outright by the other house. Two, if the houses have finally disagreed on specific amendments. Or three, if more than 6 months have passed since the other house received the bill without passing it.
This is pretty rare, though, isn't it?
Very rare. The joint sitting provision has been invoked only 3 times since 1950.
Which were?
The Dowry Prohibition Bill in 1960, the Banking Service Commission Repeal Bill in 1977, and the Prevention of Terrorism Bill, or POTA, in 2002. It's usually reserved for politically contentious bills.
Now let's turn back to the asymmetry of power between the houses. While the Lok Sabha dominates finance, the Rajya Sabha has several special and exclusive powers that underline its vital federal role. These are crucial distinctions.
There are 4 primary exclusive powers that reinforce the Rajya Sabha's status and protect the interests of the states.
What's the first one?
First, under Article 249, it can authorize Parliament to make laws on a subject in the state list. This is a centralizing power, but the permission has to come from the Rajya Sabha, the voice of the states.
So the states themselves have to agree to the center stepping into their domain.
Essentially, yes. Second, under Article 312, it can authorize Parliament to create new all-India services, like the IAS or IKS. Since these services staff key posts in state machinery, their creation requires the specific sanction of the state's representatives.
That's fascinating. It's a check to protect federalism.
It is. The third power is about the removal of the vice president under Article 67. A resolution for their removal can be introduced only in the Rajya Sabha.
Because the VP is also the chairman of the Rajya Sabha.
Exactly. The proceedings have to start in the chamber he presides over.
And the final exclusive power.
The fourth is crucial during an emergency. If a proclamation of emergency is issued when the Lok Sabha is dissolved, the proclamation can remain effective if it's approved by the Rajya Sabha alone. It ensures administrative continuity.
Moving on from the floor of the House, let's talk about the unsung heroes of legislative work, the parliamentary committees.
Indeed. The bulk of serious technical scrutiny is delegated to these committees. They're essential for tackling the high volume and complexity of modern legislation we talked about earlier.
Let's focus on the departmental standing committees, DRSCs first.
The DRSCs operate year-round. Their core mission is detailed scrutiny. They consider the demands for grants of ministries before they are voted on in the Lok Sabha. They also examine bills, scrutinize annual reports, and consider long-term policy documents.
They do the heavy lifting that the full House doesn't have time for.
That's a good way to put it. Then you have ad hoc committees, which are temporary. They're set up to inquire into and report on a specific subject, and then they're disbanded.
And what about the Committee of Privileges? It sounds a bit like an internal affairs division.
It's semi-judicial in nature. Its purpose is to examine cases of breach of privilege, that is, the rights and immunities of the houses and their members, and then recommend appropriate action, even punishment. It's a mechanism of self-regulation.
Finally, let's revisit the external checks on Parliament, focusing again on judicial review and clarifying the limits of individual member immunity.
Judicial review, as we established, is fundamental. Both the Supreme Court and the High Courts can declare laws enacted by Parliament as void and ultra-vires if they contravene any provision of the Constitution, especially fundamental rights.
And on a personal level, what are the limits on an MP's immunity from arrest?
This is a key practical detail. Individual privileges grant members immunity from arrest only in civil cases. This immunity applies during the session and for 40 days before and 40 days after a session.
Only civil cases. So if an MP is suspected of a serious crime or faces preventive detention, that immunity is gone.
Absolutely. The privilege of immunity does not apply to criminal cases or cases involving preventive detention. It ensures that while legislative work is protected, members are not placed above the criminal law. They are accountable just like any ordinary citizen.
We've seen today how Parliament operates not just as a lawmaking body, but as the central point of democratic accountability, a system deliberately structured to prevent the very concentration of power it seeks to wield.
This balance is maintained through the dual executives, constitutional supremacy reinforced by judicial review, the asymmetry of power between the houses, and those special federal checks built into the Rajya Sabha.
Remember, for the UPSC exam, understanding these nuances is what elevates your answer from just, regurgitating information to actual insight.
Right. We covered why the Indian Parliament is limited compared to the British model, the constitutional differences between a censure motion and a no-confidence motion, the legal evolution from the Quixote-Holohan case.
And the critical role of committees in managing the technical demands of governance. These distinctions are absolutely non-negotiable for high-level preparation.
If this deep dive helped you grasp these vital constitutional provisions, please subscribe to the channel and give this video a like. Your interaction really helps us reach more learners.
And a humble request again to all our listeners. Your support through paid membership enables us to continue offering this rigorous level of content. It's instrumental to our mission. So if you are capable, please do consider joining.
For everyone, remember that free notes summarizing this entire deep dive, along with practice PYQs, are available on our Telegram channel. Just search for us there.
And for our Legend YouTube members, you get access to premium notes, extra PYQs, and Model Mains answers for those complex essay-type questions. That's all available on our Discord channel. Join us there to elevate your preparation and discuss strategy.
Before we wrap up, let's revisit that core tension of federalism we highlighted today. We discussed how the Rajya Sabha has the unique power to authorize Parliament to create new All India services under Article 312.
Right.
So consider this again as your final deep thought. Why is this specific power, which potentially encroaches on state autonomy by creating central cadres that staff state machinery uniquely placed in the upper house, the Rajya Sabha, the very voice of the states, and not the directly elected Lok Sabha? What does that arrangement reveal about the Constituent Assembly's intention regarding federal checks and balances? And what mechanism of trust and protection did the framers build into Article 312? Mull over that constitutional philosophy.
Until next time, keep exploring, keep learning, and thank you for taking the deep dive with us.